Good morning. Good morning. I call this meeting of the Privileges and Elections Committee to order. If the clerk will please open the rolls and members mark your attendance. And we do have a quorum. And so our first order of business will be to turn to Chair Glass for the subcommittee report on elections administration.
Gratitude, Madam Chair. We heard three bills that we recommended for reporting. First is Senate Bill 165 from Senator Reed. This bill is very straightforward. It simply clarifies that the petition signatures can be collected on or after January 1st. Currently, the law says signature collections can begin after January 1st, and the recent opinion of the Attorney General held that the signatures collected on January 1st do not count towards required number. The subcommittee recommends reporting this bill on a vote of 8-0, and I so move.
Second.
It's been moved and properly seconded for us to report Senate Bill 165. Are there any questions or comments from the committee? Seeing none, if the clerk will please open the rolls and members cast your votes. And that does report on a vote of 20-0. Delegate Glass, Chair Glass.
Thank you, Madam Chair. Next up is Senate Bill 301 by Senator DeStef. This bill would establish an appeals process for any person or committee that has assessed a civil penalty under the Campaign Finance Disclosure Act. Upon petition, the State Board of Elections may provide relief to the petitioner for a show of good cause shown. Such relief may be included forgiveness of all or a portion of the assessed civil penalty, the retroactive extension of the deadline, or other appropriate remedy. The subcommittee recommends reporting this bill on a vote of 5-3, and I so move.
And actually, Madam Chair, if I could ask you to rescind that motion. Oh, wait. We're on 301. Yeah. Okay.
Senate Bill 301.
And if I can ask you to rescind that motion.
I recommend I will remove my motion.
Okay, and there was further conversation on what the bill actually did and what we were trying to do. And I know Delegate Sickles, Chair Sickles, you had been working on this. Do you have any comments?
Thank you, Madam Chair. Yeah, I voted for this bill and think we need something like this. And so I tried to get an amendment for this morning. I talked to the patron about it. He was fine with the amendment, but we don't have it acceptable right now. What we really need to do, if we're going to create an appeals process, we need to have a little bit more substance on how it works and some guidance for the department to follow in the appeals process. So I want this to pass in the proper form, but I think it's better if we just go by for the year and work on it, and we can get it done next January when we get back. So I would move that we carry over SB 301.
Second. Madam Chair.
Delegate Bloxham.
Do we not have another meeting next week?
We do.
Would you be acceptable to try to work on it over the next week to try to get it in the proper form?
We can delay the inevitable if that's what you would like.
Please, thank you.
Sure. So there is a motion on the floor that has been seconded. Would anybody like to rescind their motion?
Yeah, I will withdraw my motion that we carry over and see if we can work something out between now and our.
So without objection, that bill will go by for the day.
Thank you.
Delegate Glass.
Gratitude, Madam Chair. Just for clarity, we're moving on to Senate Bill 364. Okay. Senate Bill 364 is presented by Senator Evan. This bill has a substitute. I move to adopt the substitute.
Second.
Madam Chair.
Delegate Bloxham.
I've talked with the senator, and I think that I want to make sure that we protect all classes in with the election process. And I think I've talked with the council, and will be able to fix the problem next week.
So,
We could have this just go by this week so we can get it in the proper form.
well, just for transparency's sake, can you talk through what your suggestion was?
The class of protected voters, I don't think included employees. And I want to make sure that the employees' addresses are also protected.
Madam Attorney?
Madam Chair, the language is a little vague, so I think we can tighten it up in a couple of places. So I'll work on that substitute before next session, for next meeting.
Thank you.
And so was that a motion for the bill to go by for the day? It's been moved and properly seconded for the bill to go by for the day. All those in favor say aye. Any opposed? And so that bill will go by for the day. Delegate Glass?
Yes, Madam Chair, we have two bills that we recommended continuing to 2025. The first bill is Senate Bill 270 by Senator Subramanian. This one is allows political parties to hold presidential primaries using ballots that allow voters to rank towards such parties' candidates in their order. The bill includes a reenactment clause. The subcommittee recommends continuing to 2024. Or 25, and I so move.
It's been moved and properly seconded for, did you do both? I'm sorry, or 270 and 315?
I did not go through 315.
Can you go on and describe 315
Yes.
as well?
So Senate Bill 315, this provides that the information gathered by the Department of Motor Vehicles for a person who's already registered to vote will be automatically transmitted to the Department of Elections for the purposes of updating existing voter registration record, name, address change, or to return the voter to the active status from inactive status as appropriate. Under current law, a person must be presented with the option to decline to have their information transmitted to the Department of Elections before any information is transmitted. This bill also was recommended by the subcommittee to be continued to 2024, and I so move.
It's been moved and properly seconded for Senate Bill 270 and Senate Bill 315 to be continued to the 2025 session under Rule 22. All those in favor, please say aye. Any opposed? Those two bills are carried over. Does that complete your report?
Thank you, Madam Chair. That does complete my report.
Okay, awesome. So if we will now, having taken two bills by for the day, just reminding us that our last meeting is next Friday, and we are now moving to Senate Bill 406. Senator Durant.
Good morning, Madam Chair, members of the committee. Okay, so Senate Bill 406. This bill is in regards to sample ballots, not authorized by getting to the code section of whether it shall be unlawful for any person to print or circulate any such unofficial sample ballots unless the following requirements are met. They shall not be printed on white paper, and they shall include on their face of the word sample ballot, and they shall bear the legend and include the statement paid for by the name of the sponsor as defined already in code, and shall state whether they are authorized by a political party bearing the legend, or shall include the statement authorized by the name of a political party or not authorized by a political party, and disclose any statement required by this section shall be displayed in a conspicuous manner in font size no less than 24. So the genesis of this bill, Madam Chair, members of the committee, is it had to do with some incidents that came up during the last election cycle where some folks that were distributing some sample ballots that were, I guess you could say, they were disingenuous to voters as they were coming up during early voting with bearing some information that they had received an endorsement from political parties on both sides of the aisle. So particularly in the cases where, as we all know, when we have down ballot races, if they're not maybe Senate or House of Delegates, or you have more information, but there's, clerk of the court, sheriff, those type of things, that people are relying on the sample ballots to have trust and faith. And I think the crux of this is when voters come to the ballot, we want them to get fair information, honest information, not to be to get anything that they can't have faith in the system. And so if you've really earned that, if you've earned an endorsement, that should be transparent to voters as they come, and they're not getting that. And what we saw, particularly is there were folks that maybe were trusting that information, such as maybe were the elderly folks, that sort of thing, that were very frustrated because they thought they were getting a sample ballot that reflected what they thought was honest and fair information. It wasn't the case. And so, after doing a little bit of more research on this issue, it's become a lot more apparent that this is not just unique to what I saw in my district, but it's been happening across the state. And so it's very important, as we know, that we can't suppress speech. People have got to be able to say what they're going to say, but at least we can give them some more upfront and transparent information of what you can expect, especially if you're coming in and you're saying, I've got an idea in my head, I've seen the commercials, I've seen the mailers, and I know who I support, but I'm not really quite sure what's going on with the clerk of the court or if what's maybe the board of supervisors and the like. So that is the genesis of what we're trying to do. And I do have the Spotsylvania Commonwealth's attorney here who I worked with on this, who's here as a witness to kind of explain a little bit of how we work this from the legal side of that. And he did actually there was some legal efforts that came in behind that, so he can talk a little bit more about it, Chair.
Okay, before we go to public comment, I do want to check in and see if there are any questions from the committee. Seeing none, Delegate Green.
Madam Chair, how did this come out of the Senate, and were there any objections to this?
Madam Chair, Delegate Green, it came out unanimous.
Yeah, and thank you for your question, Delegate Green. I will also recommend that you remember House Bill 1314 was identical, and so we don't always take the direction from the Senate. We do have identical bills that were heard before this committee.
We've got to have that balance.
If there's anyone here to testify in support of the bill, please come forward.
Did you want to go first? Okay. Good morning. My name is Ryan Mahaffey. I'm the Commonwealth Attorney for Spotsylvania County. I appreciate the opportunity to comment today. Madam Chair, may it please the committee, I'd first like to put a finer point on exactly what the need is for this bill. So in our last election cycle, there were a number of bad actors that took sample ballots that looked exactly like the Republican sample ballot and looked exactly like the Democratic sample ballot, except different bubbles were filled in on each. And they were submitted to voters as they were getting into early voting, just as they were crossing that yellow line that nobody can go past. And people were relying on those sample ballots and casting their votes, thinking that they were voting for the Republican or the Democratic endorsed candidate, when in fact they were not. So this prevents bad actors from tricking people into voting for them. It is a bipartisan bill. It's sponsored by Ms. Durant, or Senator Durant. It was supported in the Senate by both the local NAACP committee and the local Democratic committee, and I myself, who was the Republican candidate for Spotsylvania County Commonwealth Attorney, spoke in support of it also. In our district, it was an issue that was very important to voters on both sides of the aisle, and it was a pressing matter for everybody. There was a lot of effort that went into pushing back on the people that were doing this. As the code is written, a person can create a ballot that appears to be the Republican or Democratic sample ballot, but they can mark whoever they want as the endorsed Republican or Democratic candidates. A fake sample ballot could look exactly like the Republican or Democratic sample ballots, except with different bubbles filled in. 24.2-622, as it's written, only requires a disclosure line of who paid for the sample ballot if the person spends over $200. You can print a lot of sample ballots with straight up lies on them for less than $200. And that actually happened in this last election cycle. And then once that person gets to that $200 threshold because they've reached $198 at Kinko's, they can just get somebody else that hasn't contributed anything financially to somebody's campaign fund, and they'll do it again. So even when $200 is spent, the disclosure of who paid for the ballot need only be in 7-point font, which is that. So that's what somebody has to look at to figure out that that is not the sample ballot. In that split second, an elderly person is supposed to figure out that this is not the real sample ballot of the Republican or Democratic Party. So the law expects an elderly person with poor eyesight to notice and be able to read a 7-point font, fine print disclosure line at the footer of a sample ballot. The law would then expect that elderly person to understand that a sample ballot that is labeled Democrat-endorsed candidates or Republican-endorsed candidates might not be an accurate list of the Democratic or Republican-endorsed candidates. In fact, it might just be a bold-faced lie. The law then expects the elderly person to know it might be a lie solely because the fine print disclosure line, which only exists if the person spent over $200, is on that sample ballot. And then as more than one elderly person expressed to me at early voting last year, how can they get away with this? Well, right now the law allows them to do so. So to talk a little bit about why that is, some abstract principles.
And there is someone else that wants to testify, if you could start to summarize your thoughts. Thank you.
Sure, I will. So political speech is rightly afforded robust First Amendment protection. Misinformation is tolerated so truth is not suppressed. The marketplace of ideas expects competing ideas to clash and the truth to emerge. But the marketplace of ideas needs opportunity to function. And in the context of sample ballots, most people are given the sample ballot moments before they cross a line that prohibits any further speech, which is 40 feet from the polling door. There's little opportunity for counter speech. There's little opportunity for the marketplace of ideas to function. And as a practical matter, competing for a few moments of attention as someone is walking into the polling station becomes highly contested and uncomfortable for many voters. This is what the ballot or the law as written would require. You can put whatever you want right here. It just has to say sample ballot, who paid for it, and whether it was endorsed by a political party. That's all. You can say whatever you want underneath of that. This is a good law that will give voters the information that they need to make an informed decision about whether the sample ballot they were given is trustworthy. Thank you.
Thank you. Please come forward.
Good morning, Madam Chair and members of the committee. I'm Mary Crutchfield with the League of Women Voters of Virginia. The League of Women Voters supports SB 406, tightening and clarifying the conditions for producing and distributing sample ballots, and in particular, requiring that sample ballots include the names and affiliations of their sponsors, further reduces the temptation to buy votes and confuse voters. The League strongly supports increased transparency around sources and content of campaign funding and materials. Thank you.
Thank you. Is there anyone in the room to testify in opposition to the bill? Okay, thank you. Senator, did you want to have the last word?
I think we pretty much summarized that. It's, in Virginia, Madam Chair and members of the committee, we all know we're readily aware we do not get a break with elections. So this is something that I think we're going to continue to come forth in each of the elections, and the intention, which is to make sure that we're being as transparent and honest with voters so that they're not frustrated or disillusioned, is certainly, I think, a good step forward from the General Assembly. Thank you.
Thank you. Turning to the committee, Delegate Cole.
Thank you, Madam Chair. Speaking to the bill.
Sure.
Thank you, Madam Chair. I think this is a bill that's definitely needed, and I want to thank both our Commonwealth's attorney and Senator Durant from willing to work on this bill. I've had so many different people from the local Democratic Committee come to me, even members of the local NAACP who came to me, who stated that we needed this. And I even remember during the campaign cycle, an older gentleman who went to go vote was receiving this ballot, this sample ballot, and was excited to go vote for the candidates who he thought that his local Democratic Committee had recommended to him. Only to come out to be handed the real Democratic sample ballot, and the names that he voted for were not the recommended names on the real Democratic ballot. I also carried this bill, and we were made aware of some issues in the language, and I want to make sure that we have the opportunity to work through this. So I would ask that we just continue to take a look at this, work through it, and figure out a way, because I think there were 3 issues that we need to work on, and I'm willing to work with the senator on that.
Madam Chair?
Yeah. Yes.
Yeah, would it be, I'm not aware of any, we have had some discussion, but I'm not aware what the concerns were, if they came from legislative services, if there was challenge in the code that this would be a constitutional issue or a challenge with it. It was not flagged from legislative services that this would pose any challenges. So is there some sections that were shared with you?
Yeah, and I can probably chime in here. We were definitely very gracious because a lot of the other bills that had identical language did not get afforded a full hearing. And so we are going to stay consistent with our action with the House bill so that the language can get done. I think some of the folks on this side have expressed to Delegate Cole exactly what some of those issues were, whether it was vague language, not being clear, the fact that I think we heard $200 today, but then in code there's $25,000. So the motion for House Bill 1314 was for it to be continued to 2025 with an earnest opportunity for us to look at the language to get it better. I would also suggest that we definitely go through some of the lawyers that work here that are our lawyers that really know what we like our bills to look like, at least for the next coming years. And I'm sorry, we're not taking any further testimony.
Yeah,
But
I think we have.
Delegate Fowler.
Madam Chair, since we already agreed and dealt with this issue and said we were going to work on it in the future and continue it, I move to carry this bill over to 2025.
Madam Chair, I had my light on and wanted to speak to the bill first.
Okay, we have a motion and a second. It's been moved and properly seconded for us to continue
motion.
Senate Bill 406 to the 2025 session.
Madam Chair, speaking to the motion.
I'm sorry?
Speaking to the motion.
Sure.
Thank you, Madam Chair. I disagree with the motion to continue to the next year because this is an issue that not only affected the elderly but also the minorities, specifically people English as a second language. There was actually an entire news article that was written about a man who went in and took one of these sample ballots that was printed on blue paper and believed those to be the Democrat endorsed candidates and Democrat nominated candidates. And very disingenuous and very misleading. And there are bad actors out there, and I think that we should do what we can this year to address this. And so I do not support continuing to 2025.
Thank you, and I absolutely look forward to continuing to work with you for minorities and English as a second language, folks.
Madam Chair? May I?
There is a motion. Are you speaking to the motion?
Yes, I think I am, Madam Chair.
Sure, Delegate Milday.
I wasn't clear. Could you attempt to articulate the problems that we have with the bill in its current form? You referenced something about the dollar amount, or there's some other, when you say constitutional challenges, can someone be more specific? Can you at least get that out there so we know why we're doing this? Because I am not clear on that.
Madam Chair, can I speak? Speaking to the bill?
You don't have to speak to the bill because I'm not sure that was actually speaking to the motion.
The motion.
The motion to
So if you would
pacify,
like to speak
or continue, I'm wondering why we're doing that, yes.
Madam Chair, I think I can answer Delegate. I've got a few notes here from the Commonwealth's attorney that there was some, I think, a vague as to the definition of political party. Original language is claiming political party, no prohibition against that. And I did hear from a previous bill that there is going to be one more. You have something that's carried by. I'm happy to work with Delegate Cole to get with legislative attorneys from the House to make sure that we're not out of compliance with Virginia code so that the voters of this election cycle have transparency and honesty and we don't continue to have this issue before the November elections.
There is a motion and a second. Is anyone rescinding their motion or their second? It's been moved and properly seconded for us to continue Senate Bill 406 to the 2025 session under Rule 22. All those in favor, please say aye. Any opposed? So that bill is continued.
Thank you very much.
Thank you. And we will go at ease. I do believe that Senator Boysko has an amendment, so we do want to give her the opportunity. I'm not sure. Okay. Perfect. The committee will go at ease and we'll get Senator Boysko. Thank you. Come back to order. Senator Boysko.
Madam Chair, thank you for hearing my bill, SB 377. This is a transparency bill that limits our use of our campaign funds. According to the Pew Research Center polling, a trust in elected officials is at an all-time low. Elected officials are running for office to serve them, not to serve themselves. And I ask you to think about the most recent abuse of campaign funds. And the person that comes to my mind is former Congressman George Santos, a Republican from New York who was expelled from Congress after a report by House investigators found substantial evidence that he had committed federal crimes. Mr. Santos had diverted tens of thousands of dollars of campaign money towards his own personal expenses, including luxury goods. Atlantic City casinos, rent payments, and even a website primarily known for explicit sexual content. He spent money on spa days, on vacations, on items from luxury retailers, and rent. Here is what is so disturbing to me is that in Virginia, the vast majority of his spending currently is legal here in our Commonwealth for our races and in our current campaign finance laws. While our donors expect us to use our funds to win our own elections and help others, or pay for reasonable costs that have an immediate connection with our service as elected officials, any of us could buy luxury items for ourselves. We could take everybody in this room on a spa day if we wanted, or even a luxury vacation. I don't think that's right, and I don't think you do either. So my bill puts reasonable spending limits on how candidates or elected officials can use funds that are entrusted to us by our donors. And there is a negligible fiscal impact statement, according to JLARC. I ask that you pass this bill to the Senate floor. And I'm happy to to the House floor. And I ask if you have questions, I'm happy to answer them about the specifics of the bill.
Sure, thank you, Senator. And we did hear Delegate Simon's HB 40 for reference for the committee. Are there any questions from the committee? Okay, is there anyone here to testify in support of Senate Bill 377? Please come forward.
Madam Chair and members of the committee, Mary Crutchfield speaking on behalf of the League of Women Voters of Virginia. The League of Women Voters of Virginia supports SB 377, as we do its companion in the House, HB 40. We also do not oppose the amendments approved by the committee, although we continue to believe such limitations are not needed. Currently, Virginia has no legal restrictions on how candidates can use their campaign funds, except for surplus funds at the end of a campaign or term of office. As such, Virginia has earned its rank as the number 46 out of 51 on the Nonpartisan Coalition for Integrity's SWAMP Index. Thank you.
Thank you, Madam Chair. I'm here, I'm Jeff Coop. I'm from Richmond, and I'm also a member of Money Out VA. We're a nonpartisan group that advocates for campaign finance reform. My expertise is civic education, and I am a bit shocked that this bill has not been passed before. As I understand it, this version of this bill has been put forward since 2014, so I guess we're at the 10-year mark. It was killed last year in this subcommittee, and one of the members of this committee exclaimed that Virginians want this bill. And I think Virginians do want this bill. I certainly want this bill. It is common sense. It mirrors legislation on both the federal and the state sides when it comes to personal use restrictions. It's not a gotcha bill. It provides a system of guidance to legislators, and it also protects them from frivolous complaints lodged against them, and it establishes a robust and confidential review process in case of complaint. It also doesn't cost anything. So there are no cost implications or fiscal impact to this bill. So we kindly ask, once and for all, that there be a vote for good governance here, and we thank Senator Boysko for her commitment to good governance. Thank you.
Okay, thank you. And before we go online, is there anyone here to testify in opposition to the bill? Okay. We are going to go online, and if you can each take 1 minute and tell us that I see you've signed up to support the bill. Excuse me, and we'll start with Jessica Mott.
My name's Jessica Mott. Thank you for the opportunity to testify. I'm from Arlington, Virginia, and I'm a member of We Have Action, WOFA. As Senator Boysko mentioned, this is very important for voter trust. And it includes strong provisions to prevent and penalize frivolous complaints. This should prevent inappropriate accusations. In fact, the clarity in the guidelines should help strengthen legislators' ability to defend themselves from negative publicity, even if it's not a formal legal complaint. The actual incidence of formal complaints stemming from the enactment of legislation is likely to be negligible based on my perusal over the last several years of news articles related to campaign finance in other states. Accordingly, the Department of Elections and legal authorities should easily be able to handle implementation within their existing budgets. Further, legislators will not be burdened.
Thank you. Bill Millhauser?
Yes. Good morning, Madam Chairman and members of the committee. Thank you for the opportunity to testify this morning. My name is Bill Millhauser. I'm a resident of Fairfax County. I support SB 377, which restricts the personal use of campaign funds. It's high time the legislature finally adopts this common sense measure, which will ensure certainty and accountability with regard to the use of campaign funds. Efforts to pass this legislation have now gone on for over 10 years. Now is the time to act. I can't tell you how many of my friends and neighbors shake their head in disbelief when I explain that Virginia has no guidelines to prevent the misuse of campaign funds. SB 377 has strong bipartisan support in the Senate, passing the full Senate 35-4. The House companion bill, HB 340, passed this committee 21-0, yet died in the Appropriations Committee due to confusion over the costs of implementation. This despite compelling comments from JLARC, which showed that information from several states indicated that implementation costs
Thank you,
minimal.
Mr. Millhauser. Thank you. Turning to the committee, Delegate Bloxham.
Just a quick question, Madam Chair. Is this identical to Delegate Solomon's bill?
Madam Attorney?
Delegate Bloxham, Madam Chair, it's not exactly identical, but the only two differences, it's one's in the title of the bill, and then the other one is in the enactment clause. It's simply like a canned language issue, but the substance of the bill itself is identical.
A question for the patron.
Delegate Bloxham?
So who can file a complaint against me?
Thank you, Delegate Bloxham. At this point, for the, a second.
I think the attorney can also help.
Thank you. The attorney can answer those questions for you.
Madam Chair, Delegate Bloxham, in the bill as it currently is before us, anyone who made a contribution to a candidate could file the complaint, and any qualified voter or any voter who'd be qualified to vote in that particular election for that candidate is eligible to file based on the bill before us.
Delegate Bloxham?
So if someone gives me $1, then they will be eligible to file a complaint against me?
Madam Attorney?
Madam Chair, Delegate Bloxham, yes.
And follow-up question?
Delegate Bloxham?
No matter where that person lives?
Madam Chair, Delegate Bloxham,
Madam
yes.
Attorney?
Thank you.
Delegate Milday?
Thank you, Madam Chair. Speaking to the bill. I'm new here, and it's beyond me how this bill keeps failing. In all these problems that reasons that are being cited for failing this bill. there's no way these couldn't have been worked out in the last decade. Voters do not like the idea of us using our campaign funds to do things that are not campaign related. It's a great political hit if you can get it on your opponent and everyone knows it. The only rationale I can see for some of us resisting this after 10 years is because they want to have the flexibility to buy things that really aren't campaign related things. And I just can't believe we can't get together on this and do this, pass this common sense bill. So I'm a little frustrated that this got killed and that it's probably heading to the same fate.
Delegate Maldonado.
Thank you, Madam Chair. I want to thank the patron for bringing this bill forward. I agree that people want this, and I would like to make a motion to move to report.
The proper motion at this time, after having received a letter, is to report and refer.
Thank you, Madam Chair. I move to report and refer to appropriations.
I'm sorry. There were Delegate Gilbert. I'm sorry.
Speaking to the motion. Yes, ma'am. Thank you, Madam Chair. I fully support the intent of the bill and the patron, and I fully supported the efforts on the House side. I just want to draw some attention to what I consider drafting issues. You know, I always say around here we pass laws, not ideas, and so the words have to be very precise. And I come at this from a perspective of somebody who has additional duties and has had additional duties in this space that involve incurring financial obligations and paying for things, basically. In my previous role, the role before that, the role I have now, I have to travel a lot, support candidates, go to national events. These are concerns that I would think are those of the current speaker as well, because he has those similar duties. So I'm just, in terms of drafting, and I just want to draw the patron's attention to this just so we can try to perhaps be more precise. All the things you say that you shouldn't be able to pay for, Senator, obviously, right? Like, obviously. And if those things have happened, good Lord, I'm sure they have, or they wouldn't be on this list. But so if let's say I have to travel to another part of Virginia to support a candidate or their campaign, not my campaign, their campaign, and then maybe I have to get on a plane to go to a national event to raise money to support that same person or a collective group. I'm just looking at the list. So for otherwise authorized expenditures in connection with a candidate's campaign, well, it's not mine. Number two, for ordinary and necessary expenses incurred in connection with the duties of the individual as an office holder. Well, I guess you could argue that I am doing my duty as an office holder, but it's not really directly related to my duty as the elected delegate for the 33rd District of the House. It's some other function because of my leadership position, et cetera. And I'm just wondering how that's going to be construed. Is it going to be construed against me? In terms of how liberally that is applied. It is a duty. It is a function of some other elected office I have within the context of my role here in my caucus, but it's not necessarily that of being in the office to which I was elected. So if I have to pay for parking at the airport, or if I have to pay for gas to get to Southwest Virginia, or lodging in Virginia Beach because I can't make it home at night because I got out of the event at 11 o'clock at night. And by the way, I've already missed work that day, and I'm going to miss work the next day. And so being out of work for 2 days and incurring the financial hit that this means for me personally, and I chose to do this. I'm not complaining. I'm just saying I don't want to choose to incur those financial obligations, losses, and then also have to pay for the privilege of getting the hotel room that it takes me away from the thing I could have been doing otherwise. Again, I chose to do this, but I want to make sure that I can use the natural, funds that are available to support those bigger campaign activities, and just to make sure that the drafting reflects those things that may not have been thought of. And that's all. I'm only raising it so that we can try to be more precise and maybe more forgiving in that context, not in the context of the things we're trying to keep people from doing that are obviously something the public expects that we should not be doing. So.
And so I'm not sure if there was an amendment offered in
No,
there. I did just want to say that I think when, if I might, when Delegate Simon was going through House Bill 40, for some of the questions like those, I would point to the advisory opinions and being able to get that opinion. And if you got the advisory opinion, it was covered, right, under if you were to able to, if you did something that you received guidance on, you were covered under it. And so I'm not sure, honestly, if you're working toward an amendment or if there's something, because I think, you know, as elected officials, point well taken.
Well, that's helpful, Madam Chair, and I appreciate that guidance, but I'm just trying to read it on the fly here and absorb it, and I know we're sending it to Appropriations to look at it as well, but I just wanted to say yes, but time out, let's make sure we're getting it right, and that's all.
And Madam Chair, Delegate Gilbert, my intention was that as you are carrying out your role as an elected official or in your campaign to help other people, that would be part of the ability to use the funds. It's specifically intended so that I don't take my best friend to the Caribbean on a cruise for a week with my campaign funds and misuse. I think that everyone who I know last year I had a role that required me to raise and travel for other people in the Senate. And it was very clear that when I was getting donations from individuals, they knew exactly what I was doing with that to help other people in my role as the caucus fundraising chair. So yes, I had the same issue with you, and I think that we are in a place that should be permissible. And if it doesn't, then I would like to have someone tell me, because I would not want to preclude that.
Yes, ma'am. Thank you, Senator. Thank you, Madam Chair.
And I'm sorry, I was just conferring, because this is fascinating, but there was, I guess, a pressure valve in there for, it says, for any other lawful activities, right? So you know, but I did hear Delegate Maldonado with a motion. It was properly seconded. So it has been moved and properly seconded for Senate Bill 377 to be reported and referred to Appropriations. Seeing no further questions, if the clerk will please open the rolls. And if members will please cast your votes. And so that is recommended to be reported on a vote of 20-1. Thank you, Senator. Oh, excuse me. Is that because the leader was here? Okay. So that is recommended to be reported and referred. It's reported and referred to the Committee on Appropriations on a vote of 21-0. Thank you, Senator.
Thank you, Chair. Thank you, Committee.
And so I do just want to make one announcement. We had 2 bills go by for the day. We have a few more. Next week, the only subcommittee that will be meeting is the Elections Administration Subcommittee, 4 o'clock on Monday, and then we will have full committee there. Are there any questions? I will entertain a motion to adjourn. It's been moved and properly seconded that we adjourn. All those in favor say aye. Any opposed? We are adjourned. Thank you.